you very much to everyone for coming tonight. First of all, I'll give you a little bit of background about me and what I do. I'm a lawyer. I specialize in M&A, corporate, IP, and securities laws. Obviously Italian by background, as you can tell from my name. I came to the US, I think this week is 18 years ago. I was in law school at Berkeley in California, where I got a master's in 2003, and then an SJD, which is a PhD in law. I also work as an adjunct professor at Fordham, and recently I started working as assistant deputy general counsel at R3. What you will learn today is something a little high level. I would like to discuss what are the legal best practices for you guys. I assume most of you are founders at this point, or you're thinking about setting your own startup. I'm sure most of you have heard about trademarks, copyrights, and patents. They're different things. Trademark is typically something that protects the brand names and logos used on any goods or services. Copyright, it protects an original artistic or literary work. So a copyright is, for example, if you write an article, you can copyright it. A patent protects an invention. An example that I gave you, and I apologize because I realize it's a very simple example, but you invent a revolutionary vacuum cleaner, then at that point, you would apply for a patent to protect your invention. For a trademark to protect the brand name, assume you come up with a very interesting idea, a very distinctive idea, and that's actually a term that you need to keep in the back of your mind. And then a copyright, assume you want to go for a TV commercial and there's some text and you can copyright that text that you develop in connection with the advertising. So let's start with trademarks. Trademark is really generally a word, a phrase, or a symbol or design or a combination of them that identifies and distinguishes the source of the goods of one party from others. Differently, a service mark is really the same as a trademark, except that it identifies and distinguishes the source of a service rather than the goods. So as you develop your business, bear in mind nowadays, more and more businesses get international. You may need legal protection, not just in the United States, but also legal protection elsewhere. Always speak to a lawyer and ask the lawyer the question, do you think that this is something valuable? Do you think that this is something distinctive? And do I really have any claim? Can I trademark it? And any lawyer will really be able to give you a quick analysis and let you know whether it does even make sense to spend the money that you will need to spend for the registration. Moving on to patents. So what is a patent? The patent is really an invention that you have. Once you get a patent, you are granted as the inventor certain rights. In the United States, you typically apply to the United States Patent and Trademark Office. That's obviously the same for both for trademark and for patents. And by virtue of that application, you get protection in all of the federal states. But then you also need to deal, similarly to what I was explaining for trademarks, to the extent you want protection abroad, you also need to apply for protection in different countries. There are really different types of patents. There are utility patents that may be granted to anyone who invents or discovers any new or useful process, machine, or article of manufacture, for example. And then there are design patents, and these really cover more of the design of an article of manufacture that you create. And then there are plant patents that are granted to anyone who invents or discovers any new variety of a plant. So the same that I was saying to trademarks, whenever you have an idea and you think it's patentable, you always go to a lawyer. You get a lawyer involved and you ask them the question, do you think this is something original? Do you think that this is something that does constitute an invention? And is this something that you will get some patent right protection for? For example, for our business, copyrights is the thing that we need to protect the least. As a matter of fact, I haven't dealt at my company with any copyright protection issue, while we deal extensively with outside counsel for both trademarks and patents. And obviously, even though most startups will have an in-house lawyer once they grow and they become bigger, always bear in mind, whenever you want to apply for a patent or trademarks, there's always some need to get an attorney that really specializes just in that, because there are lawyers like me that do a little bit of everything and they have general expertise, and then there are those other attorneys that really just understand one thing, and on that one thing they're really the best in the market. Trade secrets, really what it means is a secret device or technique that is used by a company in creating its products or services. So this is really the secret sauce of your business. Historically, they were not protected, but then on May 1, 2016, President Obama signed the Defend Trade Secrets Act, and that created definitely a federal cause of action for misappropriating trade secrets, which means that your trade secrets nowadays in the US are considered valuable intellectual property, and you can get form of protection, even though not a registration that you're getting for copyrights, patents, and trademarks. And then there's the know-how. Know-how, I'm sure most of you probably know what that means, but that's like really the practical knowledge that you develop. When you're hiring someone new in a company, it always takes a little time for them to understand the processes and the way people work, and that's like really an intense know-how that is a very valuable asset of any business. The other slide that for me was important, and maybe this is more for the type of business and the industry I'm in, is licensing intellectual property. So once you have your intellectual property protected, what you can do is always you can license it. Licensing an intellectual property really create a way for you to make revenue, although you always need a license agreement in place, and that's something that definitely needs some lawyers. For example, in my company, our licensing agreements are still pretty much not heavily negotiated, but we do accept comments here and there, so we always need a lawyer involved, and because some of the provisions really require some expertise. A license agreement is really a legal contract between two parties. One is the licensor, so the licensor would be you and your company that is licensing something for which you have intellectual property rights, and the licensee is the party that deals with you. In a typical licensing agreement, the licensor grants the licensee the right to produce and sell certain goods, apply a brand name or a trademark, or use the patented technology owned by the licensor. For example, we have our own software product that is available both as open source or as Corda Enterprise, which is the proprietary version. For that, we do enter into license agreement. Obviously, we have our template, and you will need a lawyer to really develop that form for you. Familiarize yourself with the type of licenses. You will learn certain terms. Some of them may be exclusive or non-exclusive. So exclusive meaning, for example, we want most of our clients to just use our proprietary software and not other software. In exchange for the agreement, so as consideration for entering into the agreement and being able to use your software or whatever you guys have developed, the licensee typically pays some royalties or some other fees or some consideration, and that's how really your company will become valuable. For example, for our company, the revenue that we're generating through our licensing is really what I consider the core revenue of our business. You will learn what is object code and what is source code. Maybe what I can tell you is that object code is really when you are licensing the output of what you created versus source code, which is when you are licensing the code as it's written, and so you really give access to much more valuable information. The things that are really always important to include in a license agreement, in my view, some clauses, for example, that prevent the licensee from reverse engineering or recompiling or disassembling the code so that they can really understand what is your secret code. And there are other limitations. For example, you may license a product for non-commercial use, or you may license it for commercial use. And obviously the economic value really changes, because if the licensee can sublicense, do I want any monetary compensation for that or not? You will have to ask yourself the question, do I need to incorporate? Why don't I need to incorporate? Do I want to be an incorporated entity? Do I not want to be an incorporated entity? So the key is really understanding the concept of limited liability and why we should care, and why in the beginning of your business it's an important decision to make whether you want to incorporate and the type of entity that you want to select. So for you to understand the concept of limited liability, an asset is really something of value to you personally or to your business. So there are some personal assets that you have, and the examples I was making here are your house and your personal bank account. Those belong to you. And then there are the business assets. Those are really the property that is owned by your business and the revenue that is generated by your business. So you can be responsible for something, either as an individual or as a business owner. As an individual, every month you pay your mortgage, every month you pay your credit card debt, I hope. So those are really liabilities that belong to you. And then there are business liabilities, and those are any debt of your business, any payables of your business. So, for example, you may have suppliers that bring stuff to you, that bring the food and the snacks for the employees, and those are all liabilities of your business. The concept of limited liabilities is really something very important in the beginning of your considerations regarding whether to start your own business or not. What limited liability does is restricts your responsibility for business losses, debts, and obligation. So what it does, it separates your personal assets and liability from the assets and liabilities of your company. The reason why the limited liability exists is really to encourage people to take business risk without the fear of losing your personal assets. So when you start the company, you want to make sure that your company is completely segregated and separated for anything that belongs to you personally as an individual. The unincorporated entities are really entities that do not receive legal protection, in the sense that do not have the benefit of the limited liability concept that I was just describing. And then the incorporated entities are entities where you get the benefit of limited liability. There's a number of options available in the state of New York, in Delaware, and pretty much anywhere in the United States. So concept of sole proprietorship, most businesses are really started out. It doesn't really require any filing at all. The only filing that you would have to make is filing a certificate of assumed name if you're operating your business under a name that is different from your name and last name. There are a lot of disadvantages, in my view, to the sole proprietorship, so I don't even want to go about the advantages. The advantages is really like it's cheaper. But what is really a problem is that you get unlimited and direct liability. So you're really not creating any division between what you own as a person and what your business owns. General partnership is the other type. In addition to the fact that each partner is equally liable for the obligations of the general partnership, there's also a need to consider that you may need some sort of agreement with your business partners. General partnership, I don't recommend, because they really don't provide any sort of protection of your business or for your personal assets. So in summary, really, the unincorporated business entities that have lower startup costs, lower maintenance costs, obviously no filings needed really. There are usually no formal steps to take. However, they always expose you to personal liability, so it's not something that I would recommend. And moving on to the incorporated business entities, this is where there's really a number of options available. And so the first one is really limited partnership. And the second one, and probably more interesting to most of you, is a corporation. As I said, there are two main types of corporation. There's the C corporation and the S corporation, and then the LLC. And then the last type that really sometimes comes across, but I don't think it's going to be the case for most of you, are really the business entities for professionals. For example, in all the law firms are LLP. So limited partnership is the first form of incorporated business entity. What really happens here, there's really at least one general partner and one limited partner. General partner is similar to the partners of general partnership, meaning they don't have limited liability. And then the limited partners have limited liabilities. This is a form that was very popular years ago, and I find it less and less popular. In terms of requirements, what I don't like is the publication requirements. Whenever you want to create a limited partnership in New York, for example, you need to publish notice of your limited partnership with 2 newspapers in the country where a limited partnership is located. One needs to be a daily newspaper, one needs to be a weekly newspaper. This is actually not just for a limited partnership. So this is also for the LLC. So, it's something that your lawyer will be able to to advise on. The advantages and the disadvantages. The advantage is that the limited partners do not have personal liability, but in my view, and obviously, unless there are particular tax reasons that a CPA can describe to you, I would never really go for a limited partnership, but I would much rather select either a C Corp or an LLC. And by the way, every time you are incorporating an entity, people tend to go first to lawyers. I think that that's a mistake. I would always go to a CPA and explain the nature of your business, or to a tax accountant, and really see what they recommend. At the end of the day, it's really like 90% of the case they're going to recommend either a C Corp or an LLC, but always go and speak to them and see what, from a tax standpoint, you should consider. So corporations, there's really two types of corporations. There's the C corporation, that is the selection that is done by default. And then there's the S corporation that is different in that it really requires a specific election. The documents that are needed, and you will see that the nomenclature is somehow different from the LLC and the corporations, are a certificate of incorporations and the bylaws. Things to consider: you need shareholders. So who are the shareholders? The shareholders are really the owners of the corporation. So you sometimes hear people saying, oh, he owns 5% of this or that corporation. That's a shareholder. And then the other actors or key players are the board of directors. So typically, New York or Delaware don't require you more than one director, but depending on the nature of the business, depending on the type of decisions you're making, you may have a board that is more complex. Then there are the officers. Those are like really the high-level employees, like the CEO, the CFO, and the employees that are typically hired by the board of officers. The pros and cons of the C corporations, the thing that is most important for you to think of is C corporations are double taxed. So you are both taxed at the company level. So whenever you have any revenue that you generate as a company, that's going to be taxed. But also the way those corporations give money back to you as a shareholder, so as a company, they give you back dividends, and those are taxed again. When you hear the concept of double taxation, that's what it means. For this reason, a lot of people prefer the S corporations. The S corporations is really a pass-through treatment, meaning they're not taxed at the company level. So if you're a shareholder of an S Corp, you're only taxed on your own income statement personally, and not at the corporation level. Now, the problem that S corporations have, and the reason why you don't see a lot of S corporation around, is that they can't have more of 100 shareholders. So when you're starting your business, always think, oh, you know, it's always easier to say, oh, I would like an S Corp, because obviously I don't have the double taxation, but you can't have more than 100 shareholders, which maybe today may sound like, oh, that it's impossible that I will have more than 100 shareholders, but you never know. You may be successful, and you may have a lot more than 100 shareholders a few years from now. All of the shareholders must be individuals, and no shareholders can be a non-resident alien. So if you're ever planning on having any foreign investors, which nowadays may happen, and your business may get global, so don't choose the S Corp. The other selection that people nowadays really make is the limited liability company. Together with the C Corp is really the way to go for most businesses. So it has some tax efficiencies of a partnership, meaning as a partnership, it can avoid the double taxation. However, to avoid the double taxation and to effectively act as a pass-through, then you will need to make that election at the time of incorporation, or you can even make it later on through a subsequent filing, but you need to make the election to be treated as a partnership. And then at that point, you will avoid the double taxation. So the members are really the key players here, and not the shareholders. So what you refer in a corporation as shareholders, in an LLC, you will refer to them as members. Members are really the owners of an LLC. Members obviously make most of the decisions. The name of the the name of the documentation is a little different, where for the corporation you have the certificate of incorporation. Here you will hear talking about the articles of organization, and then the bylaws. As the difference between the two documents is like really the articles of organization is like a one-page document that you file, for example, with the Secretary of State of Delaware or New York, that really tells you the name and that the company is formed and the purpose. And then the bylaws are a document that really regulate much more the life of the company, and say the board of directors and composition of the board of directors and how decision-making process is made. And sometimes there are certain rights in case one of the shareholders or the members for an LLC wants to sell their percentage, etc. All of these are things that are really addressed in the bylaws. So the bylaws are really a much more complex document legally, and they're usually typically like 30 pages at least. So advantages, the flexibility. They're very flexible to organize. They're very flexible to manage. The one thing I forgot to mention about the slide prior, there are the publication requirements with an LLC. So always keep those in mind, but obviously a lawyer will get involved and probably will inform you at the time. And maybe the things to consider as a disadvantage may be the complex tax and accounting issues that may apply. And in case you want the pass-through treatment, you need to make a partnership election. So always speak to tax accountant and explain what your business is, and they'll be able to really give you the best solution. The next slide is really going to a different topic, and this is like the confidentiality and NDAs. These are extremely valuable and important document for you to consider. When do you need them? So there's going to be a time in your business where you have a very valuable idea and you really want to come, for example, and discuss with people at Amazon and say, this is my idea, what do you guys think about it? Always try and enter into, if possible, an NDA. An NDA is a non-disclosure agreement, so it creates an obligation to privacy and compel those who agree to keep any specified information top secret or secured. So you can conveniently go and speak to a potential business partner and explain your idea, and if you have entered into an NDA, everything will be covered probably under that NDA. So there are a lot of issues with NDAs, and sometimes people say to me, hey, can I just use that form that I found online? And I say, well, be very careful. Like always, if you can, get a lawyer involved, at least for the first NDA, so that you have a template, a form that you will use with all of your clients, and not make it an aggressive template. So always tell the lawyer, I need a mutual NDA. What does mutual mean? It's going to cover both the receiving party and the disclosing party. So it's an agreement that is really meant to cover both parties and their respective proprietary information. Make it mutual. A lot of times people come to me and say, hey, we're dealing with this company. They don't want to use our form. Can we use their form? And then they send me a form, and I was like, listen, this is not a mutual NDA. So either I'm going to mark it up entirely, or I can just send my NDA, which is mutual and exactly has the same set of obligations for both parties. So for me, probably because my company is very global, there's the issue of applicable law. A lot of times people will come to you and say, hey, can we apply Mexican law? Hey, can we apply Hong Kong law? In reality, initially, at least when our business was a little younger, we would always say, no, we only want New York, we don't want Delaware, we want the things that we're used to. And then we transitioned to the laws of England and Wales, which are also something very standard, and most lawyers know, and they kind of like give you a level of security. And now we move to a different concept. Like if it's a country where we do extensive business, we should rely on their laws, and so we accept it. And then the other issue is make sure that the agreement is mutual, the term of the agreement. So the confidentiality information, for example, in the mutual NDA that we have and that we use as a company, the term is indefinite, so there's really no term. So every time you deal with us, we will disclose confidentiality information and things that for us are really valuable, and we have the expectation that you'll keep those confidential even like 5 years from now, 6 years from now. So we do not include a term. Sometimes people will negotiate on a term. That's okay. It creates more of a problem for you because maybe a year later you're speaking, imagine, with Amazon today, and they agree and they sign an NDA. But there's a 1-year term, and then a year later you go back and Amazon say, hey, we have an NDA in place, but then you don't know and you don't remember that the term is actually about to expire or has already expired. So it's always better to me to have indefinite terms, or at least always bear in mind that if you're using the same confidentiality provision or later on, check if the term is still valid. A lot of people come to you and say, okay, what is confidential information? That's obviously very important. So the definition of confidential information, we need a lawyer to work on it. We know how to do it very easy. But in a lot of cases, people will say, nothing oral is confidential. So I hate that. Because the way that works, and I say it's only going to be confidential is after you disclose it to me orally, you come to me and you put it in writing and you send an email exactly with what you said orally and said that that is to be maintained confidential. So I don't like that. That creates a crazy obligation for my business team. And also, it really prevents meaningful negotiations from happening. So if you will ever hire a lawyer who's going to say, hey, I'm going to say that only information that you reduce to writing is going to have to be treated as confidential, I don't know. Like, I personally don't like it, and I think it's a bad idea, and it's not going to make you look good as a business. And then other provisions maybe to think about when you have confidentiality agreements is the so-called residuals. So what you can do, what you can retain after the agreement expires and terminates, etc. There may be situations where you are required by law to maintain certain information, and lawyers are able to explain to you what those are. Founders agreement, very valuable and very important agreement. It's a contract that a company founders enter into themselves and that governs their business relationship. These agreements really are the quintessential initial agreements for you when you start the business. They really outline the rights, the responsibilities, the liabilities, the obligations of each of the founders. They're heavily negotiated. So it's not like really a template that you can use. These are things that you need to discuss with your co-founder and say, I would like A, Y, and Z, and then your co-founder is going to say what they would like. And how are we going to transfer ownership? I assume you want to exit from the business. Can you do it freely? What terms of confidentiality obligation do we need? How do we, in case there's a dispute over decision making, imagine you're two founders, you can't agree on something. So how do you agree? You always want to create a sort of a dispute mechanism and things like that. All of those are really important issues that you need to address properly since the beginning. So additional ways for lawyers to get involved. Where are you incorporating? You may need a lawyer, and you also may need a CPA. IP protection, what we were saying before. What's your IP? What's valuable? What can you protect? What can you not protect? Which countries? Are you just doing business in the US? So it's federal protection all you need, or do you need to go globally? When you go globally, how do you do that? How do you handle outside counsel? Who's going to help you? Founders agreement, so you have co-founders, discuss with them all the issues, just make sure everything you reduce in writing is going to make it a lot easier. And then confidentiality agreements, so just never go around and share your idea, especially if it's valuable, with anyone unless you have a confidentiality agreement in place. So when you want to raise funds, you start with seed financing. Seed financing is something really small in value, like it can be $10,000 to $50,000, and obviously it requires less legal documentation. You will need a lawyer to really help you and guide you step by steps and understanding what's needed, what's not needed, and what you should negotiate for, because every time you're getting an investor, they'll become corners with you. So they will want certain rights, and they will come to you, they'll be aggressive, and you may want to have a lawyer represent you on your side. And then from seed financing, hopefully you will move to what is called more like venture financing, which is like pretty much essentially the same, but larger rounds of financing that are extremely complex. What I hope you guys take back home today from the presentation in general is try to be very mindful of the preliminary steps. There are things that you don't consider, and people sometimes underestimate lawyers because we are annoying and we come there and we just create problems. It's not necessarily true. good lawyers solve your problems early on and create legal documentation that is going to help you effectively manage your business. Thank you so much. If you guys need anything, just text me, email me, and I'll respond.